So New York State, you want to continue violating the constitutional rights of your own residents? Well, game on. On February 20th, 2024, Gun Owners of America and Gun Owners Foundation petitioned the U.S. Supreme Court for a writ of certiorari. This is a direct challenge to the Bruen response bill that New York State erroneously calls the Concealed Carry Improvement Act. Now, the Second Amendment in New York was finally recognized by the Supreme Court in a case called New York State Rifle and Pistol versus Bruen. That case essentially told New York State that they could no longer restrict the ability of New York residents to carry a firearm in public for protection. In response to the defeat heard around the country, Kathy Hochul and her band of angry gun grabbers decided to create new legislation, completely ignoring the Supreme Court's decision in Bruen and Justice Clarence Thomas's requirement that gun laws must meet historical tradition. Among other things, Hochul's so-called Concealed Carry Improvement Act was a de facto prohibition on public carry. It would appear that New York was making a statement that if they would be forced to issue licenses after Bruen to citizens and recognize their God-given right to self-defense, the state would make sure to make it as difficult as possible to actually carry a gun. The new anti-gun law started by imposing novel and onerous licensing requirements, but it didn't stop there. The angry and reactive response to the Bruen decision also prohibited carrying virtually everywhere in the state. It did this by declaring practically every public space a new sensitive location. So the angry response to New Yorkers being handed back their God-given right would be to turn the state of New York into a giant gun-free zone. In that moment, New York State spit in the eye of the Supreme Court and wiped their feet on the Constitution. Of course, GOA challenged the new so-called Concealed Carry Improvement Act with support from federal court judge Glenn Sotheby, and were successful in getting several of its major provisions blocked. But the Second Circuit Court of Appeals intervened on behalf of the anti-gunners and has since kept much of the challenged law in place. The provisions of the law that are still in effect require concealed carry applicants to display good moral character, have in-person interviews with law enforcement, provide 4 character references, and undergo 18 hours of combined training and course study. GOA's Senior Vice President Eric Pratt issued the following statement. New York politicians just couldn't help themselves when they quickly doubled down with their unconstitutional edicts following the Bruen decision. I'm incredibly confident the justice will take an extra close look at this case since their previous ruling was ignored by the insubordinate tyrants in Albany. We're excited about the opportunity to serve Kathy Hochul and her cabal another plate of humble pie if the court takes this case. New York State, we didn't ask for this fight, but we'll engage if necessary. We're calling on the Supreme Court to remind you of your boundaries and demand that you respect the constitutional rights of your citizens. Thanks for watching Bullet Points. I'm Dan Wos for Gun Owners Foundation. You can find more Second Amendment content and updates at gunowners.com.